Welcome to Schiffman Firm. Premises liability is an area of law governing the legal responsibilities of owners or occupiers of land for certain injuries suffered by people on their property. Property owners, typically businesses or homeowners, have a duty to keep their premises in a reasonably safe condition. They must remove known hazards and, in certain circumstances, keep a vigilant watch for dangerous conditions of their property. If a landowner is negligent, fails to maintain their property, and someone gets hurt, the injured victim may be entitled to recover monetary damages. Premises liability claims often involve types of incidents you have likely heard of, such as slip and fall or trip and fall accidents. However, this area of law is broad and can include accidents caused by defective sidewalks, walkways or roadways, falling debris, inadequate lighting, dangerous steps or stairways, negligent maintenance or security measures, unsafe accumulations of ice, snow or liquid, defective elevators or escalators, and even construction accidents. One of the main questions in a premises case is whether the owner or possessor of land owed a duty to the injured person. Under the law, this question is answered by determining the legal status of the injured person. Generally, an entrant upon land is considered to have the legal status of an invitee, licensee, or trespasser. An invitee is owed the highest duty of care of any entrant upon the land. This duty of care is owed whether they are a public invitee, a person who is on the premises as a member of the general public and is using the land for the purposes which the owner has opened it up to the public, or a business visitor, an invitee on the premises for purposes associated with the owner's business or commercial interests. If the person is an invitee, the landowner has a duty to make the property reasonably safe by actively checking the property for dangerous conditions and remedying these conditions or protecting against them. Even if the landowner is unaware of the hazardous condition, they may be found responsible if a reasonable inspection would have revealed it. This is known as constructive notice. One typically qualifies as a business invitee when they are visiting an office building, doctor's office, retail store, mall, pharmacy, or other commercial location. A licensee is a person who is allowed to enter and remain on land through the owner's consent. Generally, this status applies to social guests. If a person were to visit a friend's home and enter their house or apartment, they are probably a licensee. In these scenarios, a possessor of land may be liable if they know or have reason to know of a dangerous condition on the property, which involves an unreasonable risk of harm, and they failed to make the condition safe or warn of the condition and risk. A trespasser is one who enters or remains upon land without the possessor's consent. A trespasser is owed very little duty, or in some circumstances, no duty at all. An owner is typically not required to take any measures to make their property reasonably safe for a trespasser. To recover damages as a trespasser, the injured person would need to prove that the landowner was guilty of misconduct, willful and wanton conduct, or some purposeful action designed to harm those entering the property. However, an owner is not entitled to indifferent, attractive, nuanced conditions of his property if these conditions may entice trespassers into a dangerous situation. Also, children are often owed a higher duty of care, even if they are trespassers. Most premises liability claims are pursued on negligence theories, but other legal theories may also apply. If you or a loved one sustained serious injuries on a premises liability accident, call Schiffman Firm at 412-PRODUCT. We will be happy to evaluate your case through our legal intake department, and an experienced civil litigation trial attorney will return your call right away.